Okay, members. I have received notice from the Minister of Justice that she wishes to make a statement. Before I call the Minister, I remind members here in the Chamber that in light of social distancing being observed by the parties, the Speaker's ruling that members must be in the Chamber to hear a statement if they wish to ask a question has been relaxed. Members participating remotely must make sure that their name is on a speaking list if they wish to be called. Members present in the Chamber must also do this by rising in their places or by notifying the Business Office or Speaker's table directly. I remind members to be concise in asking their questions. I would also remind members that in accordance with long-established procedure, points of order are not normally taken during a statement or the question period afterwards, and I call the Minister.
Thank you, Mr. Speaker. The Assembly debated a motion in September 2020 to have legislation similar to Helen's Law introduced in Northern Ireland, inspired by the campaign by Charlotte Murray's family. Responding to that debate, I committed to give careful consideration to the need for change, and if change was appropriate, determine how this could best be tailored for Northern Ireland. My statement today is an opportunity for members to hear the outcome of that review and my planned next steps. Members will recall that Charlotte went missing in October 2012 and that despite her body never having been found, her former partner John Miller was convicted of her murder in October 2019. It is impossible to imagine what a devastating impact her death and subsequently not knowing what happened to Charlotte or where her body lies has on her family. It is greatly to their credit that following his sentencing in 2020, Charlotte's family launched a campaign to have Charlotte's Law introduced in Northern Ireland. Her family has been joined in its campaign by the Dorian family, who continue to campaign to find Lisa and to get justice for her. Lisa Dorian disappeared on the 28th of February 2005 after a party at a caravan park in Ballyhalbert. Despite offers of rewards and numerous appeals for information, her body has never been found. And to date, no one has been prosecuted in connection with her disappearance. Having followed the long and determined journey of Helen McCourt's mother in England, which eventually resulted in introduction of the Prisoners' Disclosure of Information About Victims Act 2020, or Helen's Law, the families here called for similar legislation to be brought forward in this jurisdiction. Helen's Law is aimed at encouraging the disclosure of the location of victims' remains in no-body cases. It does this by placing a requirement on the Parole Board to consider the prisoner's failure to provide information. This failure then becomes part of the deliberations on whether the prisoner is suitable for release on licence at the end of the life sentence tariff period. This was a bittersweet win for Helen's family, as her murderer was released from prison shortly before the new law came into force. However, their campaign was not in vain. While it was too late to help in Helen's case, it was not long before the new provisions were used. In October 2021, the media reported 2 separate cases where Helen's Law had played a part in the parole decision to refuse prisoners' release. My department has completed a thorough review of the position in Northern Ireland, engaging with victims' families and those agencies and bodies involved at every stage of the criminal justice process. We have looked at potential reasons for non-disclosure, and we have looked in detail at every opportunity where disclosure could be encouraged. We have identified a range of creative options unique to Northern Ireland, which build upon and go further than the provisions of Helen's Law. A report detailing these has been produced, highlighting the potential for encouraging disclosure at the investigation and prosecution stages, at conviction and in the pre-sentence and sentencing stages, early post-conviction, during the tariff period and finally during the parole process. The report, which is detailed and informative, is available from the Assembly Library. Its proposals include a number of administrative measures, some of which build on existing arrangements, others introducing a new approach, and a range of potential legislative measures upon which I intend to consult. Starting with the investigation. From the outset, I believe there is value in unequivocally making the suspect aware of the importance to victims' families of disclosure and of the potential consequences for the suspect of failing to disclose vital information detailing what happened to the victim and the location of their remains. I have agreed that suspects should be given a written notice making this clear. The importance and benefits of effective communication between the Family Liaison Officer and the victims' families were highlighted during the review. I believe a strong focus on this relationship must be maintained so that all relevant information is shared between the police and the families and is fully considered. At the prosecution stage, contact between the prosecution and the defendant is normally limited. However, the prosecution would normally make the point to the judge about the non-disclosure being a relevant issue in sentencing. The review considered whether suspects should be charged with offences in addition to the murder charge, and, dependent upon a conviction for murder, offences such as concealment of a body or preventing burial. Such an approach was not recommended, as in practice a life sentence must be imposed where a murder charge is sustained, and further concurrent sanctions would consequently have no effect. The importance of the PPS helping victims to navigate what can be an unfamiliar and daunting prosecution process was recognised. I support this work and the PPS's continuing investment in it. The next opportunity to persuade the defendant to make a disclosure is at the point of conviction. At this stage, I consider that a clear indication given by the court to defence counsel on the need to address the failure to disclose could focus the defendant's mind on disclosure. My officials will be exploring the scope for this with the Lady Chief Justice's office. After conviction, a pre-sentence report is compiled by the probation officer assigned to the case, based on interviews with the convicted person. This is a further opportunity to impress upon the offender the likely impact of non-disclosure on the sentence that the court will impose. Sentencing for murder is a complex process. A life sentence must be imposed, together with the tariff being the minimum period the prisoner must spend in prison before he or she can be considered for release on licence. The tariff is decided after choosing the correct starting point for the particular category of murder and adjusting this to take account of aggravating and mitigating factors. I propose to consult on the current approach to sentencing for no-body murders. The consultation will also explore the possibility of an early post-sentence review of tariff for those cases where a prisoner may wish to reconsider his or her position early in the sentence. The consultation will also seek views on the application of any such new arrangements to existing prisoners, so that this measure would be meaningful to Charlotte's family. I also believe there are opportunities for working with prisoners during their sentence. In this regard, I want to explore an earlier focus on rehabilitation work and the potential for third-party intermediaries to engage with prisoners to encourage disclosure. The important facility provided by Crime Stoppers' confidential telephone service was also highlighted during the review. I support the ongoing programme of prison improvements, including the provision of in-cell telephony, which may further reduce reluctance to provide information and may result in more reports being made to Crime Stoppers. As the prisoner approaches the parole stage, I believe the probation officer has another chance to encourage them to think about the failure to disclose and should be required to explain the possible impact of continuing non-disclosure on the parole decision. We then come to the parole stage, the stage where Helen's Law activates in England and Wales. I propose to consult on the introduction of provisions similar to Helen's Law. In addition, I believe that introducing a requirement on the parole commissioners to specifically address how the non-disclosure impacts on the risk the prisoner continues to pose would have value, and I propose to seek the public's views on such a requirement. Finally, the review recognised the important work being taken forward elsewhere in the department to assist and support victims and witnesses, and I would encourage victims and witnesses to engage with us in these programmes. My intention is to launch the public consultation in the week beginning the 29th of November and to run it for an extended period of 10 weeks to take account of the Christmas period. The department will be happy to engage with consultees during the consultation period, giving respondents the opportunity to speak or otherwise communicate with the review team and discuss the best way forward. A summary of responses and a way forward report will be prepared with a view to developing any recommended legislation for introduction early in the next mandate. The Planned Miscellaneous Provisions Bill or the Sentencing Bill have been identified as potential legislative vehicles. Before I finish, Mr Speaker, I want to pay special tribute to the Murray and the Dorian families. I have been struck by the dignity and the patience they have shown throughout my department's review, and having met with them on several occasions, I want to express my genuine gratitude for their ongoing engagement. Their input helped shape the recommendations and gave me a better understanding of the issues and the concerns which we need to address. I hope that my statement today will open the conversation again and provide further opportunities for the families to appeal to anyone who has information to help locate the remains of their loved ones to come forward. Thank you.
Thank you. And I call the Chairperson for the Committee for Justice, Mervyn Storey.
Thank you, Mr Speaker, and can I thank the Minister for her statement to the House this morning. There must be nothing more devastating for families than not knowing what happened to their loved one and their body never being found, and can I concur with the comments that she has made in relation to the families that she mentioned in her final comments, and also add to that the Arkansas family. And obviously these are issues of grave concern, particularly for those families. On behalf of the Justice Committee, we welcome the review and the Minister's statement in the House today, and indeed officials from her department are due to come to the committee on Thursday of this week to discuss this very issue. Minister, as well as consulting on the potential legislative measures, you are also looking at a number of administrative measures, some of which build on existing arrangements and others introduce a new approach. What are the timescales for putting in place the administrative measures, and in particular the use of third-party intermediaries to engage with the prisoners to encourage disclosure?
Well, I thank the Chair of the Justice Committee and I thank him also for meeting with me this morning so we could discuss the statement, as I was aware that this was to come to the committee this week, and I appreciate his flexibility in that regard. Many of the proposals will not require legislative change and can therefore be taken ahead through the rest of this mandate. For those who require legislation, obviously it's important that we consult and we get those right. But I do think that a number of the non-legislative changes can be very influential, and in particular, the ability, for example, for prisoners to be able to make contact with Crime Stoppers, and also the ability to use third-party engagement, I think is absolutely critical. There are, of course, already points of contact that people can use if they wish to make disclosure. And what we will try to do, obviously, is to highlight those opportunities and ensure that where prisoners wish to make disclosure, or where they have information that they can share that may be of help to the families, that they are facilitated in doing that. But I would expect the administrative measures to be taken forward immediately in terms of the changes that are required, and certainly to be concluded in this mandate, and it would be the legislative changes then that would follow.
Thank you. And I call Gemma Dolan.
I too want to commend the courage and perseverance of the Murray and Dorian families on their campaign. Minister, what weight will the proposed statutory requirement on the parole commissioners to address the non-disclosure of a victim's remains carry compared to, for example, the weighting of good behaviour?
Well, the weighting of the different issues is a matter for the independent parole commissioners, and we can't prescribe what weight they will give to the various elements of their consideration. However, I think it is encouraging that in the case of Helen's Law in England and Wales, it has already been used on 2 occasions and has had the effect of contributing to decisions not to release a prisoner. Part of the discussion and the consideration the parole commissioners will have is as to whether or not the individual has been so rehabilitated that they no longer present a threat to the general public. It is questionable whether someone who continues to withhold information about a victim's remains has been so rehabilitated as to fulfil that requirement. But I think the important thing from our perspective is to ensure that we facilitate victims and their families in terms of being able to put forward their victim impact statement to the Parole Commissioners for consideration, but also that we require them to consider non-disclosure as one of the factors, which is currently not the case, and as I say, in England and Wales does appear to have had at least some impact.
Sinead Bradley.
Thank you, Mr. Speaker, and I also would like to acknowledge the Murray and Dorian families and the Arkansas family, but also, Minister, I'm mindful of, it's hard to visit this topic and not be mindful of the families of the disappeared who won't find any redress via this, but they're certainly living with that very same pain and injustice. Does the Minister agree with me that every single torturous day of non-disclosure should be weighed against that murderer in those cases during any deliberations of parole? And by every day, I mean from the day that person disappeared to the day where they hopefully do disclose. And also, can the Minister then look at how can we also leave on the table enough incentive to make that self-serving murderer eventually do the right thing and disclose, even if it's late in the day?
I think there are a number of things that the member has raised with which I would agree. The first is the anguish of families who have not been able to afford their relative a Christian burial, and the impact that that has on their ability to grieve and to find peace, to be able to overcome the trauma of having lost a loved one, and not to be able to do that via even the smallest dignity of being able to put flowers on a grave or to make some kind of recognition of the loss that they have. In all of these cases, the families were clear that what they want is for that information to be received at the earliest possible time. And so we have looked at the entire process from start to finish to see where we can actually drive the incentive for disclosure, not by way of offering people, if you like, a discount on their sentence, but by way of trying to encourage people to come forward because of the risk of it being a negative influence if they don't. Because I don't think that someone who takes a life should benefit, if you like, simply because they did the most minimal of dignified things to help with the recovery of the remains. One of the areas that we have looked at are those who may be further through this process and what can be done. We've talked, and I think I mentioned, about the review of tariff and the review of sentence immediately post-conviction if someone then gives up the information. And that is specifically designed to look at cases where people have continued to hold that they are not guilty throughout the process, including up to and including sentencing, but where perhaps in the wake of sentencing and faced with a life sentence and a high tariff, they may then decide that it is the time to give that information up. And there is the possibility where they have been sentenced as a murder with no body disclosure, that they can then have that reviewed at that point if they do come forward, and that can be taken account of in a retrospective review. And so we hold that out even at that late stage for someone to come forward, because frankly I would far rather people came forward in the immediate aftermath or in the sentencing than have to wait maybe 16, 17, 18 years before they actually come in front of the Parole Commissioners and then have another opportunity to make that disclosure. Much better for the families that it is disclosed as early as possible.
Thank you,
Mr. Speaker. I thank the Minister for your statement, which is really important. There's an evilness to murder, and there's a double evilness to murder when you then do not give up the body, and anybody who supports that adds to that evilness. But you did mention the proposal to consult on the current approach to sentencing for no-body murders. Could I just ask, Minister, is that going to be part of the public consultation which starts on the 29th, or is this a separate process?
No, it will be part of the consultation. One of the recommendations and one of the options that we are considering is there are different categories of murder that the member will understand. And one of the considerations is that automatically, if you haven't disclosed the whereabouts of the body, that should fall into the highest category and therefore attract the highest tariff on which the starting point for sentencing would begin. And that's one of the issues that we want to consult on as part of the wider process. That would require legislative change. So what we have done is put all of that into the public consultation, which will start at the end of this month, and will allow us then to look at a legislative vehicle in the next mandate, probably the sentencing bill, because it seems to fit in there, but also potentially the miscellaneous provisions bill, just depending on timing, that would then allow this to be brought forward and the legislation changed. The member is, of course, right that this is a package of measures, and therefore it's important, I think, we consult in one block, and also that we legislate in one block rather than tamper and tinker with small parts of the system. I think it's important that this is seen as a cohesive package, which is there specifically to meet and address the needs of families who are not only grieving, but are tortured by the fact that they do not know what happened to their relatives' remains. And the impact that has, Mr. Speaker, cannot be overstated. When you meet with those families, when you listen to their experience, it is absolutely grim that the families are still wrestling with this, often in their older years, often almost giving up hope of ever having that opportunity to have a Christian burial for their loved one. And I would just appeal to anyone out there who has information about the whereabouts of anyone whose body has been disappeared, to come forward and give that information up, because the families deserve at least that.
Thank you. Call on Muir.
Thank you, Mr. Speaker, and I welcome the Minister's statement and the proposals she set out today in the Chamber. But my thoughts immediately today are upon the families of those who have been unable to give a Christian burial to their loved ones, particularly the Murray and Dorian families. Running through Castle Park in Bangor yesterday afternoon, I was able to see a bench and flowers there to remember Lisa, but still there has been no body uncovered, nor funeral being possible. Will the Minister join with me in calling for anyone with any information whatsoever to come forward with that today? No more delay. Bring that information forward, whether it's to the police or Crime Stoppers, to ensure that the families can have peace. Thank you.
Colin Dillon.
Mr. Speaker, I would absolutely concur with my colleague. Yesterday was the National Day in the South for the victims' missing persons, and the families have worked through that to try to raise awareness and to challenge the conscience of those who know where Lisa's body is, who know what happened to her on that fateful night, and who are deliberately and willfully withholding that information from her family, from her parents and her sisters and her loved ones. I would beg people who might know to come forward and ease the pain that the family have gone through. These two families that we have dealt with directly are just two examples of many families that suffer this same indignity. And Mr. Speaker, they have shown huge grace, huge courage, huge resilience in the face of unimaginable pain. And I would appeal to those who withhold that information and continue to do so to stop, think what it would be like if it was your nearest and dearest, and come forward and give the families the information that they desperately seek.
Thank you. First of all, I apologise to the Minister for moving on there very quickly. Lena Dillon.
And thank the Minister for her statement today and concur with all of the remarks that have been made in regards to both the Murray and Dorian families, and I did meet with them whenever I was on the Justice Committee, and I think the Minister is quite correct in what she says in the dignity in which they've held themselves. Minister, just in relation to specifically the requirement on the Parole Commissioners to address how the non-disclosure of a victim's remains impacts on the risk the prisoner continues to pose, the motion passed acknowledged that such matters are already routinely considered, and I'm just wondering on that specific point what has actually changed. And if I can just add another, in the case where an appeal is ongoing, we know how slow justice can be in this jurisdiction. Is there a way of getting those appeals sped up? Because if alleged perpetrator thinks that they still have an opportunity to be found innocent, they may not be willing to disclose.
Well, answering those in reverse order, the member is of course right that unless justice is able to be speeded up, we will have continuing delay in terms of getting justice for families and resolution through the courts. And we also will then have a continuing period where people may be claiming that they're innocent when indeed they are guilty. We are, as you know, tomorrow, Mr Speaker, due to debate the Committal Reform Bill. That is an opportunity for this Assembly to show clearly that we do want to speed up justice and to move forward in respect of that. And we are also investing significant resources in terms of trying to speed up justice right from the beginning, pardon me, in terms of exchange of information between the various parties and right through the process. None of this is to remove the right of individuals to be able to get justice, whether they are the accused or whether they are the victim. But it is to say that there can be, I think, additional haste in terms of how we actually resolve these issues, and we are working hard to achieve that with our partners in the justice system. With respect to the parole review process, it is a matter for individual parole commissioners as things stand, the different issues that they will consider. And this may be one of a number of issues that they will consider. The difference is that we are making it a statutory requirement and that it will be considered as part of this. We also know that the registered victims or their nominated representative have a statutory right to have a victim impact statement submitted to the parole panel. And that is something, however, that is not always taken up. And so it is important, as part of the wider work around this, that we try to encourage those victims and their families to make use of that statutory right and to exercise it, so that when it comes to this, it is about looking at whether or not the person can be managed in the community, but also whether or not that person has rehabilitated to the extent that one would expect before release. And I think that that is the key message that we want to send.
Nicole Peter Weir.
Speaker, and I thank the Minister for her statement. I welcome the step forward that has been taken today and join with others in appealing to anyone who has information on the Dorian case, the Murray case, indeed any of the other myriad of cases where such heartache is being caused to the families by simply not even knowing the remains of their loved ones, to come forward even at this late hour. Can I ask the Minister, in terms of the centrality of the position of victims' families, whether there are any plans to have a bespoke and focused role and input for victims' families, either in the consultation or as we move forward with the legislation?
I very much appreciate the member's question, and victims' families have been at the centre of how we have taken this forward. We've worked very closely with the relatives, both of Lisa Dorian and Charlotte Murray, in consulting with them about what they desire as a result of the justice process, and also the complexities around how that can be delivered without biasing the system so far against the defendant that it would be counter to natural justice. I know that the families have been incredibly patient and understanding of the legal position and the challenges that creates in terms of what we can do. But they are very supportive, certainly, of what we have done. But of course, we are happy to meet with other families who may have similar experiences. In the last number of weeks, I met with the family of Arlene Arkinson as just one example of someone who has disappeared and her body has never been found. And I would welcome anyone who finds themselves in that situation getting in touch with the department and with my officials and giving us their feedback in terms of how this process may or may not be able to assist them in terms of recovering the bodies of their loved ones. No body murders are, Mr Speaker, thankfully a fairly rare occurrence in our society at this point in time. But that doesn't make it any less important that we ensure that at every stage of the system where those examples do happen, that we are able to do all within our power to assist the families in finding the truth and in finding the location of their loved ones' remains, so that they can offer them the burial which they would wish and have somewhere to grieve.
Mr Cathal Boylan.
Thank you, Mr Prince, for that, Speaker. And could I welcome the Minister's statement? Just, Minister, what engagement have you had with your southern counterpart in developing these proposals.
At this point, Mr Speaker, I have not had engagement with my counterpart in the South directly about this particular set of recommendations, because obviously these would pertain to cases going through the Northern Ireland court system, and our rules and regulations and so on are entirely different. However, I was due to meet with my counterpart this week. It has been postponed, but I would hope to discuss with them in due course with Minister McEntee the potential, particularly where disclosure may happen on a cross-border basis, for us to be able to pick up that information and make use of it. It is incredibly important that we recognise that in a number of cases, whilst the murder may have taken place in one jurisdiction, the body may have been located in another, and so it is important that we continue to work on a cross-border basis. But as these proposals relate solely to those elements of the justice system in Northern Ireland, I haven't consulted directly with them about these proposals.
Mr. Robin Newton.
Thank you, Mr. Principal Deputy Speaker, and I too welcome the Minister's statement. I think this is a very welcome piece of work. I imagine that the meetings that she's had with the Dorian family and the Charlotte Murray's family can have been nothing other than emotional and painful all around, and I pay tribute to them. Can I ask the Minister, even at this early stage in the process, aspects of Helen's Law have been criticised by eminent QCs in England. Is it the possibility that we can learn from what has happened in England, even at this early stage, and indeed that we can develop the legislation that will indeed give the families of the Northern Ireland victims even greater hope for the future?
Well, I thank the member for his remarks, and he is right. The families are incredible people with huge amount of courage and have, I think, an intimate understanding of the challenges that the justice system faces and a reasoned approach in terms of where they believe a difference can be made, and I have been hugely indebted to them in terms of their engagement. We would indeed want to learn from the experience of Helen's Law, whilst we are proposing to go further with the proposals that I have spoken of today. We would nevertheless want to learn about the implementation of Helen's Law in the courts in England and Wales. Obviously, their parole commissioner system is different from our own, and so not everything will immediately be able to be transferable in terms of how we take this forward. But I do think that we should look carefully, as we have in producing these recommendations, at what happens in other jurisdictions, as well as looking very carefully at the opportunities that exist in our own. And if there are lessons to be learned, if there are concerns that have been raised, and if there are ways that this can be improved, I think the consultation period is the right time for people to bring that forward for our attention so that we can engage with it. One of the reasons why I think it's so important that we do this consultation, Mr. Speaker, is that if we are going to change the law, it is important that it is part of a considered and thoughtful process, and not something that we do as a knee-jerk, albeit out of good intention, but that hasn't been properly weighed and measured in terms of its applicability and the impact that it has on the justice system as a whole. And that's the intention of going to consultation, to ensure that we get this right.
Mrs. Dolores Kelly.
Thank you, Principal Deputy Speaker and Minister. I welcome your statement and join with others in paying tribute to the families of Lisa Dorian and Ms Murray. But I also pay tribute to the families of those who were disappeared by the Provisional IRA, Columba McVeigh, Joe Liskey and Captain Robert Nerak, who have been waiting almost 40 years for the return of their bodies, and I would hope that we could use this opportunity to again call upon the Republican movement to return their remains. I note, Minister, in your statement that you talk about incentivising the prisoner or the offender, and indeed the power continues to rest with the offender to a point. I wonder, Minister, have you given, in terms of the stick approach, any thought to a whole life tariff being the ultimate penalty that any offender might pay, regardless, in terms of what some might call rehabilitation, as you yourself recognised? How can rehabilitation be thorough if indeed they haven't returned the body?
Well, I thank the member for her question. With respect to a whole life tariff, yes, it was considered and indeed it was discussed with the families, and they were very clear that their objective was not to seek that the person responsible for the murder would never see the light of day again, that was not their primary objective. Their primary objective was to uncover the remains of their relative and be allowed to bury their relative, and that was their focus. Unfortunately, with a whole life tariff, there can be no incentive for someone to give up that information, because they will be put in such a situation where they would be beyond the reach of the parole commissioners, because they would not be released at any time. And it would in fact take away an opportunity for us to work with the offender to ask them to give up that information. Of course, the other issue with the whole life tariff, and they are there for a reason, because there are some murders that are so egregious and so depraved that there is a reason why a whole life tariff is required if the individual is beyond rehabilitation. But I think that the best place for this lies with, if you like, that more serious category of murder, where the tariff is set at a relatively high level, where they have to go in front of the parole commissioner in order to have any prospect of parole. And I think in doing that, there are at least 2, if not 3, additional opportunities introduced into the system in order to try to get this information for the families that would not be there with a whole life tariff. So it isn't simply that I would object to whole life tariff where a murder has been particularly egregious, and indeed it may be appropriate in some cases, but not all. I think the key here is about trying to use the system that we have in terms of sentencing to ensure that we maximise each opportunity to get the information the families wish.
Mr. Alan Chambers.
Thank you, Mr. Principal Deputy Speaker. I welcome this bill, brought about mainly by the dreadful plight of the grieving and dignified families of Charlotte Murray and Lisa Dorian. Whilst the proposed new law will offer hope for the Murray family that the remains of their loved one could be recovered and given a Christian burial due to the fact that someone has been convicted and is currently serving a sentence for that murder, could anything be incorporated, Minister, in the new law that might encourage those who have information about a case like what happened to Lisa Dorian to come forward with this information, and in a just world, doing the right thing would remove any need for such encouragement to conclude Lisa's case, and it's not too late for someone to do the right thing? Thank you, Minister.
Well, Mr. Principal Deputy Speaker, one of the things that we considered very carefully was about the retrospective part of this, where it would be able, the review of the tariff would be able to apply even after the person has been sentenced, where that could then be reviewed if they subsequently were to give up that information. And we've made that retrospective specifically to ensure that in situations such as that of Charlotte Murray, that there would still be an incentive there for anyone with information who has been sentenced to come forward. With respect to incentivising those who are responsible for Lisa Dorian's murder, and indeed those who are aware of where her body is buried, the incentive for them, I think, comes much earlier in the system, in that if they are eventually brought to court and found guilty, it will have an impact in terms of their sentencing and tariff, and we've made that clear in the report. However, there will be those who think that if they stand by and say nothing, that they will be able to evade the courts and will be able to evade justice. And it is true that there may be some out there who have committed atrocious crimes and will never be held to account for them. The justice system can only take us so far. I wouldn't necessarily be saying that I'm appealing to people's better nature. I think somebody who would withhold this kind of information from a family perhaps has very little of a better nature to be appealed to. But I would say to those in the community who know where Lisa's body is, who know what happened to Lisa, who know who was involved in that evening's events and who were responsible for that, I would ask them to search their conscience, to consider the impact that they are having on her family, and to come forward and give up that information at the earliest possible point. You don't need to go to the police in order to do that. If you're afraid, if you feel that you may be intimidated as a result, you can phone Crime Stoppers. It is an independent charity, and you can give that information on an entirely anonymous basis. And I would encourage anyone in the community who has information that could assist with the recovery of Lisa's remains to do the right thing, to come forward and to help her family with what is just, I think, one of the most tragic situations that any family will ever face.
Ms Liz Kimmins.
I thank the Minister for her statement this morning. Minister, the statement references the potential for the court giving a clear indication to Defence Counsel on the need to address failure to disclose. I'd just be grateful if the Minister could elaborate a wee bit more about what that would mean in practice and how it differs from the written notice at investigative stage, and also would there be any opportunities to provide this at pre-court stage?
What we are going to do is explore that particular element with the Office of the Lady Chief Justice, because we think it is important that at every stage the message is reinforced throughout the system to the accused, to the convicted person, and right throughout the system, that if they continue to withhold information about where victims' remains are, that will have a negative impact on their sentencing, and it will have a negative impact on the tariff. In a murder case, the sentence will always be life. The question is how soon they will be able to seek parole on that life sentence. And I think we need to make it very clear at that time that by withholding that information, the tariff is likely to be set at a higher rate. It may in some cases also result, as I mentioned earlier, depending on the outcome of the consultation, it may result of that murder being in the more serious category automatically. And again, that's something else that would need to be reinforced with a person who is facing sentencing. It will not necessarily mean that every person who is responsible for a case like this will give that information up. Some people will continue to withhold it for whatever reason, but it is to create that incentive at each stage so that whoever is involved can give consideration to the impact, not only that they have on the family, but also that they will have on themselves if they continue to withhold that information.
Mr Stuart Dixon.
Principal Deputy Speaker, thank you, Minister, for your statement, an important one today, and particularly in relation to those families in Northern Ireland who find themselves in these circumstances. Minister, Helen McCourt's parents have been actively involved in support after murder and manslaughter, and in particular they have been exploring an area of the law with regards to the crime of prevention of burial. That does not require the perpetrator to indicate where they have disposed or how they have disposed of the remains, but that in itself as a crime carries the penalty of life imprisonment. What action is the Department taking to ensure that that sits alongside all of the actions that are taken to encourage and support these families?
Well, I thank the member for the question. It is an area that we looked at as to whether or not there should be additional offences created in this area. Given that here in Northern Ireland it is automatically a life sentence if you are charged with murder, there would be, I think, very little incentive to be created from having a separate charge which would then run concurrently with that life sentence. So essentially someone would be given concurrent sentences, and there would be very little incentive for that person then to give that information up, more than there would be with a single life sentence running on its own. So it is something that we considered. It is something that we will continue to watch in terms of developments in other places. In terms of the wider support for the victims of murder and of manslaughter, it is a huge issue for families because the court system, whilst we hope that it contributes to the grieving and healing process, very often can be traumatic in itself. And it is not every family that will get to go to court, because sometimes the perpetrators will not be caught. And so there is a real challenge around how we better support the families of those who have lost relatives in these circumstances. It is a conversation that we had last week. It was the 50th anniversary of victim support, and we were looking at how they could better support throughout the justice system and beyond the justice system those families and those individual victims who have been affected by some particularly heinous crimes. I think that is a job not just for victim support, but actually for us all as a community, because in terms of being able to find meaning in what has happened, to be able to find resolution on what has happened, and to be able to come to terms with the fact that when you have suffered this kind of loss, the old you has gone. You are a different person you are irrevocably changed by experiencing an event like this. And so there is both a grieving for the loss of the person that you love, but also a grieving for the loss of yourself, because your own self has been changed so far by these kinds of events. And so what we need to do, not just within the justice system, but beyond into health and communities, is to look at how we better support those who have been victims of crime in that journey towards finally finding some kind of peace with what has happened, because it is certainly not an easy journey.
Mr Pat Catney.
Thank you, Mr Principal Deputy Speaker. I also want to thank the Minister for his statement. I'd also like to acknowledge the Murray and the Dorian families today for being here. And I welcome the Minister's step towards embracing Charlotte's Law, and ask the Minister, can she give an assurance to this House that there will be robust safeguards in place that ensure false or misleading disclosures do not benefit those that make them, or any reduction in time due to be served?
Mr Speaker, I can give that assurance. There will always be cases where the passage of time and indeed the change in the environment will make it difficult to locate remains. We saw that even in the case of the Independent Commission for the Recovery of Victims' Remains, where even when people engaged with goodwill, they were unable to locate the places where bodies were disposed of. It often happens in haste, under cover of darkness, hidden from public view, and so it can be very difficult, even if someone intends to give the right information, for them to be in a position to do so accurately. But it would be important, I think, that we recognise that you should not benefit from any such reductions unless the information you give is bona fide and actually leads to some progress in recovery of remains. I think to do otherwise would be unfair on the families and only create more upset and distress.
Ms Rachel Woods.
Thank you, Mr Principal Deputy Speaker, and I thank the Minister for making the statement today. And my thoughts are with both Lisa and Charlotte's family and others affected by this. And I appeal again, with anyone with any information, please do come forward. Can I ask the Minister about what she means by early post-sentencing review of tariff? And does this imply in the statement that this could be applied retrospectively, and would she support that?
Yes, it does imply that it would be retrospective, and the idea would be that if somebody, after they have received their sentence and their tariff in the courts, if on reflection they decide that perhaps up to that point maintaining their plea of not guilty had been in their interests, that they may decide at that point that continuing to hold that position may no longer be so. It would be within the gift of the courts to reconsider their sentence if they were to come forward and give that information freely to the family and allow for recovery of the remains. And I think that that's quite important, because one of the things that we will be consulting on is that notion of whether or not a murder in a no-body case should go in automatically to be considered as one of the more serious cases of murder. And that could be something then that would determine the level of tariff. So it is important, I think, even at that early stage, that there is the opportunity for review. We listened very carefully to Charlotte Murray's family in particular, because they would be in that post-sentence space now and pre-parole. And so we have looked to see how we would do that, and we believe that in this case we are proposing that it would be able to work retrospectively, so that if someone comes forward at this point with that information, it would be allowed to be taken into consideration in terms of their tariff.
Mr Jim Allister.
I join the tributes to the courage and tenacity of the Murray and Dorian families, and indeed others. So as I can better understand the Minister's thought processes, could I put this to her? If someone is duly convicted of murder and they've withheld information and are sentenced on that basis with an enhanced sentence, and then the body is found through no help of theirs, but found without their help, do they get any advantage of that? In other words, is the determinant the withholding of the information, or is the determinant the absence of the body? Can you help me in that?
Determinant would be the withholding of the information in these cases. So were the body to come to light by other means, the person who has been convicted of that murder and withheld the information would not receive any benefit from the fact that the remains whereabouts have been disclosed. And I think it's important that what we are trying to do is incentivise the person most likely to know where the remains are, the person who is convicted of that murder, to come forward and give that information. In terms of the wider appeal, we make that, of course, to everyone in the community, because there may be other people, friends, relatives, acquaintances, who may have information that would help to locate the remains, and we would, of course, encourage those people also to come forward, but specifically here we are looking at those who were responsible.
Mr Alex Easton.
Thank you, Mr Principal Deputy Speaker. Can I say from the outset to the Minister I welcome her statement and the detail of the statement, and having spoken to the Dorian family this morning, I know they feel the same way as I do about your statement, so thank you. My question to the Minister is, when you mentioned about bringing forward legislation on Helen's Law that's similar, can you maybe outline what differences there may be to Helen's Law across the water? Thank you.
The key differences really will be to allow for the different structures that we have around parole and sentencing, the different sentencing structures here, and also the different issues that we have around parole. We're also, the member, if he reads the report which I've left in the Assembly Library for members, we're also looking at how sentencing would be structured in the initial stage. So all of that will be slightly different to the arrangements put in place for England and Wales, but it isn't a major deviation from the basic requirement that the parole body, whichever it may be, the parole board in England or the parole commissioners here, would have a statutory duty to consider where that information has not been disclosed.
Thank you, members. That concludes questions on the statement from the Minister of Justice. If I could ask members to just take their ease for a few moments before we move on to the next item of business.